What we're going to be doing today is looking forward to what's on the horizon on the employment law front. And we're living in interesting times this year. We have a flurry of new employment legislation, which some of which has already come in, others coming in April, which I'm going to take you through. But we also have an election almost inevitably later this year. And to an extent, labour law, employment law is going to be an issue on the agenda at that time, and that's what Andrew is going to be addressing later today. So, like one of those dodgy calendars, I'm going to take you through from the beginning of the year. The pictures start getting a bit more fuzzy as we go through the year, so some of the detail is slightly lacking, and will materialise late in a few months' time. So the first thing to talk about is annual leave and holiday pay. And these new regulations, the Amendment Employment Rights Revocation Transitional Provision Regulations 2023, which came into force on New Year's Day, generally applying to leave years which start on or after the 1st of April. So there's a little time to get your head in order for how these changes affect you from a practical level. And they make a number of substantial changes to the Working Time Regulations 1998. I'm just talking through the background to these regulations. It's part of an overall programme from the government's point of view to look at the European employment law, which has been retained after Brexit, and refining which bits need to be retained, which bits can be left behind. It's all part of that overall programme. And on the particular question around holiday pay, annual leave and holiday pay, as you're probably aware, this has been something which has been fought over through the courts really for the last 15, 20 years. Series of cases going all the way up through the European courts and also through the UK courts on a number of issues, ranging from the rolling up of holiday pay. I've mentioned that case because we'll come back to that point. More recent cases about how do you calculate holiday pay? Do you include overtime? Do you include commission bonus payments? That was the Lock and British Gas case in particular. And also, what do you do where, because of taking maternity leave or because of long-term sick leave, you're unable to exercise your holiday entitlement in the current holiday year, and the principle about being able to carry over holiday pay, and again, a series of cases around those. And the more recent case, which caused quite a few practical issues, particularly in sort of education environment, this case about term time only employees. If you remember, this was a case, it was concerning a music teacher in a private school in Bedfordshire, and the outcome of the case was, in fact, leaving those employees who were employed for the whole year but only required to work for particular parts of the year, left them better off in terms of their leave entitlement than other equivalent employees who were working throughout the year. And that was something which the government then took forward into consultation, because they recognised the sort of inherent unfairness of that. So there were two consultation papers which the government produced last year, one specifically building on the Harper Trust and Brazil case, thinking forwards to a resolution of that, but also a general policy paper, what they called a smarter regulation to grow the economy. And this was what put forward wider proposed changes to the working time regulations. So what we've now got, so in about December of last year, the government came back with its response on the consultation and didn't ultimately take forward all of the proposed changes. So we'll work through the particular changes which are being introduced and then look slightly at what they could have done, how things could have been done in a greater way. The changes are particularly affecting two categories of employee or worker, and these are what they call irregular hours workers and part-year workers. So the regulations don't affect people who are working regular hours, whether they're full-time or part-time employees. So maybe 80–90% of your workforce aren't going to be immediately impacted by these changes. But it's these two categories. So firstly, the irregular hours, and I've given you the definitions here. So if the number of paid hours that you work in each pay period under the terms of your contract is wholly or mostly variable. So it's things like your 0 hours workers or your employees who are on paid per hour. They may have a guaranteed number of hours, but actually their number of hours fluctuates month by month or week by week. So those are the sort of the typical cases of irregular hours workers. So when it comes to payroll, you're having to look back at, well, how many hours did you actually work this month before we know how much you're going to get paid? And the other category is what they call the part-year workers. So this is like in the Harper Trust case. So people who are required to work only part of the year, and there are periods where they are still employed, but they're not required to work. So, through the summer holiday or through the other term times of the year when you're not actually required to be working in those parts of the year. So how are these two categories of people affected? So the regulations create these specific rights. The first is about how do you calculate the leave entitlement? And they've done this by a formula of saying, okay, each pay period, we will look back at your hours worked in that month, and you will accrue leave based as a proportion of those hours. And this is the magic 12.07% figure. And that's worked out by looking at the proportion of holiday weeks per year compared to the actual hours worked per year. Special rules apply if somebody is off on sick leave or statutory leave. You look back at the hours worked across a 52-year period. But the default position is, well, what have you actually worked in that week or in that month? So the particular pay period. And that becomes how much leave you are accruing. So thirdly, this is the right to carry forward. What the regulations do here is to put into the body of the regulations for these two categories the principles which have come from the case law about, for example, employees taking maternity leave or those who are on long-term sick leave and as a result can't, it's not possible for them to use up their holiday in the current year, and it allows roll forward of holiday in those circumstances at least to the next holiday year. I think in some cases up to sort of 18 months from the end of that holiday year. And the last point here is that it gives the facility for employers to pay holiday pay as rolled up holiday pay. So rather than this fiction of saying, well, you are now treated as taking your holiday on a particular day during the summer holidays, for example, it gives you the option to say, here is your pay slip. This is your basic salary. Let's say it's, £100 for that particular week. Here is a separate payment, which is your rolled up holiday pay, another £12.07. So rolled up holiday, if you remember, there was a European case which didn't like the idea of it because it generally restricted employees actually taking a holiday and getting the rest and relaxation and refreshment which holiday is supposed to be giving to you. But in reality, particularly for employees like 0 hours workers and these term time workers as well, in reality, that's what employers have generally been doing. And yes, it hasn't been totally compliant with the working time regulations, but now the regulations are catching up and allowing that possibility. But just as a reminder, it doesn't give you that option to pay rolled up holiday pay for your staff who are working regular hours, be they full-time, be they part-time, throughout the year. This last change around the working time regulations, this actually applies across the board. So it's not just those two categories of employees. And it's the point about your obligation to maintain records. So as it stands under the regulations, you need to show you need to maintain records which are sufficient to show compliance with a number of the requirements under the regulations, in particular showing compliance with the maximum working week, taking annual leave, also your weekly rest periods. And what the regulations do is to say, actually, here is some flexibility for employers. The manner and format of your records is now down to your reasonable discretion, so long as you can show overall compliance. And this is rolling back from a European case. There was a case involving Deutsche Bank it was 2019 case, which suggested that employers had to keep systems for recording the actual daily working time of every individual employee, every individual worker across the business. And the government's position is that European ruling is actually disproportionate and it imposes unnecessary burdens. So as I say, now, and this change has now come into effect, you don't have to keep a record of the daily workers of every single worker, so long as across the board you can demonstrate your compliance with the regulations. And just a final point about the record keeping point, there is still no explicit obligation to keep records which show that you are complying with daily rest periods or rest breaks, or indeed the weekly rest periods. So your record keeping obligations only apply in reality to certain of your obligations under the regulations. Just before I move on from the working time regulations, and in fact, what I've done here is given you a link to the government guidance. So this is now being published. I've given you the link there, and supposedly this is simplifying the holiday entitlement and holiday pay calculations. So that is stamped all over the documentation, and I've quoted there an objective of those reforms to simplify holiday entitlement and holiday pay calculations. Sadly, I think the reality is that the regulations just add to the levels of complexity. As I say, the changes don't affect what you're having to do with 80–90% of your workforce anyway. There are some uncertainties and gremlins still within the regulations. So there are various lawyers who have slightly pulled apart the pieces of the regulations and have found various aspects in which, when it comes to the fine application of these regulations, there are going to be questions which are going to bog down the law courts for probably another 5 years in the future. There are still, for example, uncertainties about what do you do with bonuses? Are bonuses, if they're paid annually or quarterly, do you have to reflect those within the calculation of holiday time? And again, there is still, what the government didn't do was to take the wider step of saying, do you know what, let's, because as it stands, all the European cases strictly only apply to your core entitlement of 4 weeks under the Working Time Directive. They don't apply to the 1.6 additional weeks which we have under the Working Time regulations. So there is a confusing picture presented by these European cases, and the government could at this point have taken the step of saying, look, let's simplify everything across the board, take away those divisions, but they haven't done so. So there's still that two-tier system when it comes to the finer analysis of entitlements under the regulations. So sadly, the days of complexity, confusion, keeping the lawyers busy around holiday pay and holiday leave will still be with us for a number of years. Yeah, I've just given you an example there from the guidance about, and the document is useful actually as a practical document to work through, but it's given you an example of how you work out the particular entitlement in that month for this individual who's worked 68 hours in that particular month. The other change brought in by these particular regulations is around 2P consultation. So just a quick reminder, so if you're buying a business, part of a business, equally in what they call service provision changes, so you're outsourcing a part of your business, or you're changing contractors, and the various conditions for 2P applies. So ordinarily, you have this duty to provide information to your employees who are affected by the transfer, and in most circumstances also consult with those employees as well. And this is where you have the framework for consultation through elected representatives if you don't have recognised trade unions or staff councils who have that function already built into the framework. As a reminder, at the moment you've got an exemption for micro businesses. So if you have fewer than 10 employees, you don't have to go through the process of electing representatives for the purposes of providing information and consultation. And what these regulations do, and this is with effect for transfers happening after the 1st of July, it widens that exemption to if you've got fewer than 50 employees within your organisation, or you are a larger organisation, but the transfer affects fewer than 10 transferring staff. So that will cover a very large number of transactions which are covered by the 2P regulations, and it takes away the obligation to invite the relevant employees to elect representatives. There are going to be cases, however, where you're still going to want to go through that process, because let's say you've got 48 employees in your business. The idea of sitting down and providing that information and having consultation discussions with all 48 staff is going to present practical challenges. And so in that sort of situation, you may still want to go ahead and say, do you know what, let's have a framework for consulting with a number of representatives reflecting different parts of the business. Just quickly, this a slightly nerdy piece of legislation, but it's again part of the wider review of retained EU law, and it's amendments to or Equality Act amendment regulations. The effect of these is to preserve within domestic law certain nuances of discrimination law, which have only come about because of European case law. So it's particular protections around pregnancy, maternity, and childbirth, so allowing preferential treatment for employees in that situation. Wider prohibition of discriminatory recruitment statements, even though you don't have an individual who has the right to say, I am the person who has been immediately impacted by that discriminatory statement. It allows enforcement bodies, so Equality Human Rights Commission, for example, to take enforcement action where they see one of those discriminatory adverts out there. Again, the definition of disability must take into account your ability to participate in working life on an equal basis with other workers. So certain nuggets of equality law which have only developed as a result of European law, those are preserved going forwards. Right, moving on. So these are changes to statutory paternity leave, and these will come into effect. So the regulations come into force 8th of March. So they've been published as draft regulations for now, and apply where the expected week of childbirth begins after the 6th of April. Obviously, there could be children who are born before the effective week of childbirth. So in practice, could come into effect before that 6th of April date. What these regulations do is inject some elements of flexibility around statutory paternity leave, which may be some of the reasons why there is not universal take-up of these entitlements. And I'll come back and think about, well, what are some of the other reasons in a moment. But inject some flexibility. So how does this work? Firstly, it allows statutory paternity leave to be taken as two separate one-week blocks. So rather than as it stands, you have to take it as a single block of either 2 weeks or 1 week, allows you to say, right, I'm going to take 1 week now, and I'm going to take another week in, let's say, 6 weeks' time or 6 months' time, and gives greater flexibility when you can take the leave as well. So it's at any point in the first year after birth, or in the case of adoption, after adoption. So again, at the moment, you have to take the leave within the first 8 weeks after childbirth. So it gives that greater flexibility. And again, relaxation of the laws around notice requirements. So at the moment, you have to give the notice by I think it's the 15th week before the expected week of childbirth. So it's now the case, or will be the case, that in most cases, the notice period will be 4 weeks. So again, that feeds in with, well, actually, I might want to take the leave, see how it goes, and possibly take it 6 months in or 9 months in. The big thing, obviously, that hasn't changed, and this must be the biggest reason why there isn't universal take-up of entitlements, is there's no change to, number one, the overall entitlement of 2 weeks, and number two, the rate at which paternity pay is paid. And just giving you some insights around that, there was a TUC survey done in June 2023, which found 1 in 5 parents, 21% of parents, saying they didn't take any paternity leave at all. And the biggest reason for this was because they couldn't afford to reduce their income. And not surprisingly, the lower their income, the greater that was a factor. So 1 in 7, only 2/3 of fathers, partners with a household income under £25,000 were actually going to take up their entitlement. So 1/3 of fathers in that category were not taking up their rights. Similar study done by the Centre for Progressive Policy and the Pregnant That's Then Screwed charity in again June 2023, and they found almost 1/3 of fathers took no paternity leave after the birth of their last child, and they are generally campaigning to have an entitlement of 6 weeks paid at 90% of income, in line with statutory maternity pay, and also in line with a number of European countries. And there's international data which suggests if you do that, that's going to have a positive impact on the pay gap and also labour force participation gap. So it's one to look for in the future as to changes in that direction. Quickly, national minimum wage changes come into force 1st of April. Big hike, it's nearly at 10%, largely reflecting where inflation was in the last year, but also a major change of extending the national living wage to employees in the 21 and 22 age bracket. The other point to mention there, this is also expected to meet the government's overall target for the national living wage to equal 2/3 of median pay for those aged 21 and over. So that was the target set back in 2019. So obviously need to look at your pay structures in time for when these changes come into force in April. Other changes coming in April, big changes around flexible working because of these two sets of, one is the new act and the other is these regulations. So this is coming into force 6th of April. And the main change here is that the right to request flexible working becomes a day one right. So up to now, you need 26 weeks of service. Now becomes from day one of employment, you can make that application. And again, there will be the facility to make 2 requests per year rather than just 1 year request every 12 months. And again, the timescale to deal with consider applications is shortened from 3 months down to 2 months. Content of request no longer required for the employee to talk about the potential impact on the employer and what can be done to mitigate those effects. And it's all part of the principle of the flexibility for flexible working being the default position, and employers being much more open to consider that. So alongside the regulations, you've now got this new ACAS code published as a draft for now, but I don't expect there'll be any changes. And it takes into account, obviously, changes in technology, changes in general work habits and patterns post-pandemic, greater take-up of flexible working since then, and an accommodation of that. So I quoted there, the starting position should be to consider what may be possible. So that should be the new mindset. And again, some quotes from there: where possible and appropriate, employers should build flexibility into job roles when designing jobs and advertise during recruitment that they're open to discussing flexible working. Again, approach meetings with an open mind, jointly explore alternative solutions if the original request cannot be accepted. So as the overall mindset of what can we do as an employer to support you, and it's the art of achieving what's possible rather than putting up the shutters and saying no. Flexible working is the last thing we want to accommodate. So some action points I've given you therefore to look at. In particular, look at updating current policies. If you don't have a current policy, introduce a new one. Think about are we going to face more applications? Do we have the resources to deal with those? Do we have the framework to look at how flexible working is being requested and considered and granted across the business, and the outcomes of applications? Carers leave. So this is quite a radical change, described as a groundbreaking change, which potentially affects, I think, or foreseen to affect over 2 million employees across the UK. And it introduces a new entitlement to leave for those who have got these caring responsibilities. So going beyond your emergency leave for dependents, which has been there for quite a few years now, but it's this specific right to leave across the year. So in force from the 6th of April, the right to 1 week's unpaid leave to care for a dependent with a long-term care need. And it can be taken in anything from half a day to a full week off within that across the 12-month period. No service requirements, so it's a day-run right, and legal protections for those employees who the employer takes punitive action because they're exercising these rights. And I've given you there the definition of what they mean by dependents. So this actually reflects the legislation about emergency time off. So it's quite a broad definition of who can be a dependent. And it covers, for example, other people within your household who are relying on you providing that sort of care. But your typical cases are going to be around your family members, your spouse, your parents, your parents who are living with you. And then the definition of what does a long-term care need mean will largely include those covered by the Equality Act, so who have got disabilities, but equally it covers those who require care for reasons connected with their old age. Notice in order to exercise it, there's no formalities around that. So, it could just be a phone call saying, look, I need to take time off to look after my aged parent or look after my child. And that is all that needs to be done by the employee to trigger this right. They have to give you a certain amount of notice, and I've given you the formula there. So broadly speaking, it's a minimum of 3 days, but beyond that, it's twice as long as the leave that's required. You, the employer, can allow shorter notice than the legislation requires. And there is a mechanism there. If it presents awkwardness and difficulties, you can defer the request. I think in reality, it's going to be rare for employers to exercise these rights. It's a bit like with parental leave. You've got the unpaid parental leave. You've got the power as an employer to postpone when the leave is being taken. But in practice, it's going to be rare that you're going to want to take this. I suppose the big thing about this, it doesn't give the right to be paid for this period of leave. I think there will be an expectation on many employers that they will pay the employee as best practice, even though they don't have the legal right to do so. It raises the question, well, if you don't actually have the legal right to be paid when you're taking it, is it going to be a damp squib? Or is the take-up of this right going to be limited in the same way that right to unpaid parental leave, it's not very widely known about and not very widely exercised either. So again, some action points there. Really want to introduce new policies, make sure you've got your systems are properly up to date so that you can record specific absences around, well, on this particular day, Joe was taking leave in order to this was carer's leave, this wasn't holiday leave, this wasn't sick leave. So make sure that your systems are properly logging and monitoring those leave days, and make sure your managers are nicely up to speed as well. And then just finally, from me, the law around redundancy protection is being extended, as I've mentioned in these regulations. So at the moment, there is protection during maternity leave, but that legal protection, so the right to be offered any suitable alternative employment, so priority treatment in redundancy situations. This is extended now so it's during pregnancy. It goes beyond maternity leave as well, really up to I've done it here, up to 18 months from when the child is born. So it's quite a widening of those entitlements. And again, action points: make sure your policies are up to date. So things like your maternity leave policy, redundancy policies, extra care, extra caution if you're planning any reorganisations from April onwards. Again, make sure your systems are all properly logging different sorts of absences. Make sure your managers know what they're doing as well. Right, thank you very much indeed. I will pass over to my colleague, Andrew. Andrew, you're on mute, I think.
I hopefully off of mute now. Good morning, everybody, and thank you very much for listening in to Patrick and I this morning. Thank you, Patrick, for outlining what appears to be a definitive position in terms of employment law over the course of 2024. But what I wanted to do, and Patrick and I have talked about this in some detail, was to look at what a future Labour government's plans might be for employment law. We're not getting ahead of ourselves here. Nothing is certain in life. A week is a long time in politics, and all of the cliches that we are very familiar with. But I think it would be true to say that based upon the current polling intentions, which range, I believe, between 20 and 27% for the opposition Labour Party, I think it's fair to say that there is a strong probability that there will be a change of government for the first time since 2010 later this year, as Patrick alluded to in the autumn, October, November. So what we felt would be helpful, because there's some quite significant proposals that are coming through at this particular stage, but we felt it might be helpful for potential planning purposes to provide an overview of where a future Labour government might go. We're a little bit short on detail, so please forgive me for that, but certainly there's some broad themes which are beginning to come through. And self-evidently, if it does look that the opinion polls remain similar as the year progresses, we'll obviously be able to update you and provide more detail as the year progresses in our future webinars. But what I can say is that Angela Rayner, who you will know is the Shadow Deputy Prime Minister, has announced what's called a New Deal for working people. And she's pledged on behalf of the future Labour government to introduce legislation within the first 100 days of power. So, you know, if they are to come in towards the latter stages of 2024, we may well have some quite concrete proposals as we go into the early part of 2025. So as I say, short on detail at this stage, but themes are certainly developing and we will dig deeper. But if a lot of this stuff is introduced, I think it's going to be quite transformational from an HR perspective and how we deal with people issues within the workplace itself. So what I've endeavoured to do is just pick up on about 3 or 4 areas which I think are particularly relevant for the audience we have today. Firstly, I'm sure all of you are aware that the qualifying period for ordinary unfair dismissal protection is currently 2 years. It actually changed in 2012, going up from 1 to 2 years. And from 1999 to 2012, it had been 1 year. So it would be a halving of the qualifying period, as I say, from 2 down to 1 year. There is some suggestion that there could be day one rights for ordinary unfair dismissal. So in other words, you would not need a qualifying period of service. I've got to say, I think that's extremely unlikely. Whilst it is true that in a number of countries, including a number of European countries, there is a day one right for the equivalent of unfair dismissal, I think it's unlikely that the Labour government would go that far. One of the reasons is the chaotic nature of the employment tribunal system at the moment. Patrick and I are working obviously on a daily basis with the employment tribunal, and there are significant delays, and we're often seeing cases postponed right at the end of, or right just before actually a hearing is about to take place. If anyone from the employment tribunal is listening in, I may, I apologise to them on an individual basis, but certainly we are finding all sorts of problems at the moment with the employment tribunal system. When I say day one rights, of course, we do currently have day one rights in relation to whistleblowing, health and safety dismissals, etc. And of course, in terms of discrimination. But I'm talking about your ordinary unfair dismissal issues here. So, for example, your gross misconduct scenario, that type of scenario, performance related, etc., where you normally require 2 years as it currently stands. Another potential provision is the removing of limits on unfair dismissal compensation. And I'm sure many of you are aware that there is no cap limits on discrimination compensation, but there is in relation to the compensatory award and the basic award for unfair dismissal. I think there's a strong possibility, based upon what the Labour Party are currently saying, is that they would remove the cap on the compensatory award. Some of you may be aware that it's capped at the lower, I emphasise the word lower, of a year's pay for the claimant, or 105,707. So if you earn 40,000, it would be 40,000. If you earn 200,000, it would be 105,707. But it is, looking at the current language of the Labour Party, that may well be removed, and there will be no compensation cap. What Patrick and I were talking about this the other day. What has happened in recent years is we're seeing a lot of claims where people bring a claim for unfair dismissal, but they throw in another form of claim which may have less merit because they want to circumvent the compensation cap for unfair dismissal. So that will be interesting to see how that develops and evolves moving forward. Since 1996, we have in essence had 3 categories. We've had employees, this slightly nebulous concept of worker, which is separate to employee, and of course the genuine self-employed. In relation to this workers category, there's been an awful lot of litigation and case law around this, and some of you might be aware of the the Uber drivers cases. So Uber drivers are deemed as workers. They're not employees and they're not self-employed. They are workers, which gives them certain rights around minimum wage levels, around holiday pay, etc. But they would not have rights to bring claims for unfair dismissal because that currently only relates to employees. The Pimlico plumber cases was another series of cases relating to workers. But the significance of that is that if, as we suspect, a future Labour government moves towards two categories, that would be the single category of employee and worker and the category of self-employed. So removing in many ways the differentiation between employee and worker. The reality here is that workers will be able to bring a claim for unfair dismissal in certain circumstances. So in other words, there's going to be an enhancement to rights, I suspect, or we suspect, based upon what the current Labour opposition is saying. That will obviously raise some interesting points, and it could well evolve and develop. The other thing that seems to be relevant is, as I'm sure most of you, if not all of you, are aware, the primary limitation period for bringing a claim at the Employment Tribunal for discrimination, for unfair dismissal and various other claims is 3 months from either the act of discrimination or the dismissal, depending upon the case that we're dealing with. We think that that is likely to be extended to 6 months from 3 months, which could be an interesting development, because it may well be that if there is a potential claim that is looming, that an employer may be less inclined to recruit a replacement in those circumstances. And I've seen this many times where people might wait at least 3 months, employers might wait 3 months, but that may, if there is an extension, have to be extended, or the decision may be extended by the employer. We await to see, but I wouldn't be surprised if there is an extension. That, of course, would also give more time for ACAS to try and resolve the case prior to the issuing of proceedings. There could well be pros and cons in relation to that. So just as Patrick very kindly gave some action points, I would suggest that employers, with a view to these being certainly more than just possible, these reforms, I would suggest that employers are reviewing performance management, appraisal, misconduct, and grievance procedures. All of these, I think, are highly relevant, particularly if the qualifying period for unfair dismissal comes down. Consider further training for those involved in employment decisions. I think the pressure will be on, and it will be on earlier potentially. Review recruitment processes and due diligence. You won't probably have that 2-year, in inverted commas, probationary period where you can dismiss without, not always, without the fear of unfair dismissal claims, but certainly reduced risk. Review notice periods to new hires, review approach to probationary periods, and also importantly, identify whether you've got people on your books who are engaged as workers who may actually ultimately be covered by unfair dismissal protection in the event of a change in the law around employment worker status. I think that's another important point. So all of those in themselves are potentially highly relevant. Now, the next point that I wanted to raise was the 0 hours contracts. Now, 0 hours contracts have been around for an awfully long time, but we've seen an extension of the usage of them over the course, particularly of the last 20 years. And a future Labour government wants to ban them outright. And the way that they're going to do that is they want to have a situation where anyone working regular hours for 12 weeks or more will have a right to a regular contract to reflect the hours normally worked. What the Labour Party are currently saying is that there's a lot of uncertainty for employees or workers that are engaged on these 0 hours contracts, and they feel that that is unfair and is creating a number of issues. And what they want to do is, as they see it, is to remove I'm not sure if they're actually using the word exploitation, but I mean, they certainly would like to regularise and have permanent contracts for a number of these individuals that are, in essence, working regular hours over 12 weeks or more. Another, I think, important development is that, and the devil will ultimately be in the details, that they want to have a situation where if, for example, a shift is cancelled at the last minute or within a reasonable period, we don't know what that is yet because, as I say, we're still waiting for detail, the individual would be compensated for the last minute cancellation. So the employer stroke worker would be compensated, because there's a lot of evidence that people are expected to come in, say, on a Monday morning on a 0 hours contract, and it's cancelled at the last minute, and there's no compensation in those particular circumstances. So again, it's another way of regularising a working pattern. So I mean, it's been around for a long time. I mean, I remember the 2015 general election. Ed Miliband, who at the time was the leader of the opposition, made a big thing about the banning of 0 hours contracts. It didn't occur, obviously, ultimately because Cameron's government won in 2015. Although there has been a focus on banning exclusivity in 0 hours contracts. In other words, there has been a ban on organisations requiring an individual to have just exclusively be working for one employer in those circumstances. And that has gone through. But this is a further extension and ultimately will lead potentially to the banning of 0 hours contracts. So again, what steps should employers be taking at this particular stage? We're suggesting audit your current workforce to identify the proportion of workforce engaged on 0 hours contracts. Have a look at that, because ultimately within a relatively short period, you may not be able to use 0 hours contracts moving forward. Again, when you, as part of this review, see and audit how many of these workers are actually working regular hours in practice. As I said earlier, we've got this 12 weeks or more and a permanent contract where there are regular hours being used. And I think it is important that this process is being looked at now, working on the sporting probability that the Labour government, that there will be a Labour government later in 2024. And I do feel that this is something which will be implemented. I think it's something which has been on the Labour Party's agenda now for many, many years. And I think ultimately this could be their opportunity for the banning of 0 hours contracts. So, as I say, we should be reviewing this at this moment in time. Just some other proposals as well. We fully anticipate that if the Labour government does come in, that there will be a new duty on employers to take reasonable steps to prevent sexual harassment in the workplace. This would be a mandatory duty on employers. And this is likely to, so areas that employers might need to look at are things like training, new policies, but it will not be enough to have a passive approach to the prevention of sexual harassment. We consider, based upon what the Labour Party are currently saying, it will be a proactive step. And I know for a fact the number of larger training organisations are already training quite heavily, some bigger employers in relation to this at the moment. We're in full anticipation that this will come in over the course of the next 12 months or so. So just a few other points which are coming out of this. There was talk of a new ACAS code of practice, but I think that's probably unlikely based upon what I've seen. But there will be amendments and updates to the EHRC, their code and their guide, which will obviously go into more detail as to what are deemed to be reasonable steps to prevent sexual harassment in the workplace. Also, if it is that in the event of successful claim for a claimant in relation to sexual harassment, the employment tribunal will have the right to uplift damages by up to 25% if they feel that there are failings on the part of the employer and they have failed to comply with their mandatory duty. So I think, again, I think that's a very important point. I must say that Patrick and I, in our daily practice, are seeing a lot more cases around sexual harassment at the moment. And the need is very obvious, in my judgment, for training within several of these organisations that are in this litigation. The next point I wanted to raise was potentially a new right for employers' workers to disconnect outside working hours. So what I'm suggesting there, or what the potential future Labour government is saying, that it will be, and I used a new right, it's not an obligation. So in other words, there may well be provision that allows an employee not to have to answer the telephone or emails outside of working hours. This is a European provision which is seeping into potentially into the UK. It's, I think, highly relevant given the proliferation of home working that we've had, particularly since lockdown. And whilst there are existing measures, for example, health and safety legislation, working time regulations, etc., I think that what the Labour Party is believing is that they need to go further in relation to this. And you know, we are much more familiar now. I mean, I talked a lot about mental health issues in the workplace, and I think that it is seen potentially to be an exacerbator to mental health issues, where people feel they can't disconnect even outside of working hours. So it will be interesting to see if and when that measure is proposed. But as I say, it will be a right, not an obligation, which I think is relevant. There are very obvious issues around that because people work in different time zones. So it may be hard to connect. There is evidence that some parents, carers might enjoy the flexibility of logging in, taking phone calls outside of working hours. So how strict this is going to be, it's difficult to say at the moment. And I've said on several occasions, the devil ultimately is going to be in the detail with that. But certainly it looks to be a step in the right direction, at least from a well-being perspective. So I say that. So where we don't have a lot of detail is the possible enhancements to family leave rights. Patrick very eloquently took us through some of the changes which are coming in this year. I think if I was to make some predictions around this, I think that possibly a new government needs to look at the concept of shared parental leave. It's been in now, I think, since about 2015, but it's massively underutilised. I think this is the shared parental leave, as I'm sure most, if not all of you are aware, is where you can share, for example, maternity leave with your partner. And the whole idea is the equality of, let's say, for example, bringing up children. The take-up has been only 1% of mothers and 5% of fathers that are eligible have taken shared parental leave. One of the big issues is always around the payments, as Patrick alluded to earlier. And I think that it might well be that a future Labour government might look at payments around family-friendly rights and maybe increase and therefore potentially increase take-up. Certainly there's more than just anecdotal evidence to say that the take-up of some of these rights is reduced because people simply cannot afford to take time out on the statutory, or in some cases no pay at all. So I think that is relevant, but again, that requires a lot more detail, and we need to know a little bit more about that. I think it's likely that SSP provision will be increased, and I don't just mean in line with inflation. There are some suggestions, wild you might think, that suggest that that SSP might be increased from £109.40 to somewhere in the region of 65% of normal earnings. I find that highly unlikely, but I think the direction of travel is that SSP is going to be rather more than £109.40 moving forward. I fully accept that many of you, if not most of you, provide more than just basic SSP provision, but not for the 28 weeks which SSP is in for. And as you know, it only comes in from day 4 of absence, and there is no pay in the first 3 days unless there is the safety net of company sick pay. Slightly outside of the scope of our talk today is the expansion of trade union rights, but I fully expect to see the rolling back of some of the trade union legislation that was brought in by successive Conservative governments. And I think there'll be more scope for collective bargaining, fair pay agreements and things like that. But as I say, I think that's probably largely outside the scope of our talk today. And although I'd of course be delighted to talk to anyone about it if they feel it would be of value. That is the end of my whistle-stop tour of what a likely future Labour government will at least look at in terms of employment legislation. I don't know if there are any questions. I do see there's some entries in the chat box, but I'm sure Patrick and I are very happy to stick around for a few minutes to answer any questions that might be of assistance. Annie, I don't know, I haven't seen any questions, but
we got a question from Susie Locke. She's saying, "Hi Andrew, re-zero HR contracts and right to regular contract. What would be the stance if the employees refuses regular contracts?"
Hi Susie, it's been a long time since we've caught up. I think at the moment we simply don't have the detail for me to answer that question. This is all about proposals, and I think I fully accept that there are a lot of people that actually like 0 hours contracts, and I'm obviously talking from the employee worker perspective. So I actually think the point that Susie makes is a valid one, but I couldn't actually give a definitive answer to the question because we simply don't have the detail. Without wishing to put Patrick on the spot, Patrick, could you take us any further forward with that?
No, only to say when these rights are introduced, they tend to be on the focus is it's a right for the employee to make a request to regularize their employment in a different way, and so it generally allows them to maintain the status quo if that's what they prefer to do. So I suspect in that scenario, yeah, if that individual doesn't want to have a regular contract rather than a 0 hours contract, then they can carry on with what they've got. But we'll have to see.
Yeah, I mean, I think the point, Patrick, though, is that if they are outlawed and banned, and it would then depend on the enforcement process, wouldn't it? If you can't have a 0 hours contract, then we just don't know. We don't have the evidence at this stage, do we? So, no. Anything else, Annie, that's arisen?
I think Kim Smart has just put a question in. She's saying, "Would it be possible to have a copy of the presentation? Thank you for a very insightful and interesting presentation."
Okay. Well, we'll look into that. Yeah, thanks, Annie.
Yeah, I think that's all the questions. Anyone else want to unmute and ask a question to Andrew or Patrick?
Feel free to call out if anyone has a pressing question.
But otherwise, thank you everybody for your time. It's obviously a lot of material we've covered, which illustrative of interesting times that we have ahead of us. I
think Angela has just raised a question, Patrick, around the redundancy protection for pregnancy.
Okay, I will look at that.
So Angela has said, when does the redundancy protection re-pregnancy come in? Sorry, I may have missed the date.
Yeah, it is. That should be back on the slides.
Yeah.
It's generally coming in from April.
Yes.
Yeah. Beginning of April. Yeah, changes take effect 6th of April. I think it's pretty sure it's 6th of April.
That's my understanding.
Yes. Pregnancy is notified on or after the 6th of April. Statutory leave ending on or after 6th of April 24.
Yeah. Thanks for your question, Angela.
Anyone else got any more questions before we close? Nope, I think that's it. So if you have any further questions, obviously, please feel free to reach out after this webinar or get in touch with Furley Page directly. Thanks again to our guest speakers, Patrick and Andrew, for their valuable insights today. For now, thank you for joining and have a great forward day, everyone. Goodbye.